Okay, we're here with Kristin Bays, and she's a candidate for Judicial Court number 410. And I'm John Wirtz, and I'm with Pat Tibbs, Brian Crumbie, Dale Fessenden, Ken Vaughn, Bob Bagley, and Larry Rogers. And so what we'll do is start off with a 5-minute opening from Kristin, and then we'll proceed on to the Q&A for 45 minutes.
Well, thank you. Thank you for having me here this evening, and I have had the chance to meet most of you. There are really 3 things that I wanted to talk to you about before I answer your questions. One is I wanted to tell you about me. The second is about the court that I'm running for. I'm running for judge of the 410th District Court. And the third thing is why the court and I are fit. So about me. Let me tell you about the things that I care about, because as a candidate for public office, I think that's an important thing for you to know. I care about the law, which made me exceptionally nerdy in high school. People sort of made fun of me because I liked law school. I really did. There was something about legal procedures and legal analysis and understanding how you take the facts and compare them to the law and it leads to a decision. All of that really appealed to me. It was like a language that really spoke to me. But more than that, it became a more passionate thing for me because it really confirmed the whole idea that our civilization, our democracy, our country is really based upon the rule of law, because that's what gives certainty to the things that we do, what is expected of us, what we can expect of others, all of that. And it was just something that I really loved. I went on, obviously, to become a lawyer, and I have been for 22 years, and it's just really a passion that hasn't left me, so I'm still nerdy. But the other thing that I care about is Montgomery County. I came here in 1995, been here 20 plus years, and I've never looked back. I'm from Lubbock, so you can understand why I would not want to look back. I went to school at Baylor in Waco, another good reason to keep looking forward. But I love this place. I mean, you'll have trees, which is very uncommon in Lubbock, but this has really become my home. I mean, I met my husband here, I've had my children here, I've raised my children here. I've got Scott, he's a senior at Oak Ridge High School, he'll be going to college next year, and Ashley, she's a freshman over there, she'll be going soon after him. And even when they are gone, I'll be staying here. I mean, this is a place that matters to me. So it's really those 2 things that came together that made me want to run for the 410th District Court. So that's the second thing I want to talk to you about, is what this court is. It's a people's court. I mean, it really is. When the legislature set up this court, it made it a multi-jurisdictional court so that it would be available to people in Montgomery County to hear any kind of case that Montgomery County citizens needed to have heard, whether it's a civil case, family case, criminal case. This court hears all of those things. It's accessible for the people, it's available for the people. That's what it was designed to be, and that's what it needs to continue to be. It's important to have a court that can handle a multitude of cases, because this is a huge county now. It's grown by leaps and bounds in 20 years. We're at almost 500,000 people. Lots of things are happening at the courthouse. And the idea of getting rid of some of the types of cases that the 410th hears, that's not going to work. That's not good for our community. The reality is that justice delayed really is justice denied, and there's a lot of justice delayed at the Montgomery County Courthouse. That's a hard, cold reality. We have civil cases. It's taken 3 and 4 years to get these things to trial. We've got criminal cases. It's even worse. And I'll tell you, we have 600 to 700 people at the Montgomery County Jail just at any moment in time, and they're there waiting for their cases to go to trial. That's an awful lot of people who are just waiting. And for the taxpayer, that's $50 per person per day. That's $30,000 to $35,000 a day for people to be waiting. And why are they waiting? They have a constitutional right to a speedy trial. We need to get those cases to trial. We need to save the taxpayer money. We need to take care of getting these cases tried. We need to fulfill our constitutional principles, and that's why I think I'm a good fit for this court, because I'm ready to hit the ground running. The things that the court handles are things that I have experience in handling. This is what I want to do. I want to work for the people. I want to be the court for the people, and I want to put my skills to use to give something back to my community. I picked this court to run for because I was very concerned about the idea of making this change that I think would hurt our community, my home. And so I've thrown myself into this race in an attempt to try to help my community. So, with that being said, I'm ready to answer your questions.
Okay.
Thanks.
All righty. Let's see. In relation to question 2, why are you seeking suspension, the 3 primary goals that you want to be measured by if you were elected, and I go down to your response, your goals in number 4, you were alluding to the different courts of right now the 7 district courts, and the ones that we have, one family court, 3 criminal courts, 1 civil court, and 2 general jurisdiction courts, which here family, civil, criminal. Based on your experiences, what percent would you say you've had experience in each one of those, family, civil, and criminal?
My experience is primarily in civil. I would venture a guess that we're probably talking in the ballpark of 85% of the cases I've handled, maybe even more like 90. I've handled both sides of a civil case as a plaintiff representing defendants, a lot of commercial disputes, all those kinds of things. That's really been the focus of my practice. Family cases make up a large part of the remainder. I really hesitate to give you a percentage because I'm not sure, but that's a lesser part of what I handle. I also handle a lot of probate cases, which really family and probate kind of fit under the civil umbrella, but those are the cases that I handle. Criminal, it's been a handful. It has been very, very few cases. I would really venture a guess to say maybe 5 ever. And they've been misdemeanor cases while this court handles felony cases. But what I think is important is that I know how the courthouse works. I know how a courtroom works, the rules of evidence, all those types of things. I've got a lot of experience with trials. And this is a trial court. When Judge Mays took the bench, he had never had any experience in criminal, and he's really well respected by our DA's office and by the criminal defense bar alike. This is a court that does criminal. This is a court that needs somebody who's willing to jump in and do that. So although my experience is principally in civil and much less so in criminal, I have the experience to handle what the court handles.
Among the 9 justices, which one do you respect the most and why? And which one do you respect the least and why?
Well, the one that I respect the least is probably the hardest to answer because there's a whole bunch of them that are sort of tied for last place. Ruth Bader Ginsburg is really my very least favorite, and I know that lots of people would pick Sonia, and I understand that. I do. I really do. She's a real close second to worst for me. But the thing about Ruth Bader Ginsburg is she sort of has this presence of a very caring, grandmotherly person, and then she writes these opinions that are crazy, outlandish, extensive, and she has some credibility in my mind while she does it. I mean, they're all well educated, but there's something about her personality that I think makes it very dangerous when she starts with the pen. The favorite is Scalia. Anybody that works in sarcasm the way that man does, it's like an artist working with oils. He writes these opinions that are so clear, so concise, and so obviously correct that it just speaks to me. I mean, his sarcasm abounds in his opinions, and that makes them fun to read. It also makes them memorable, which is a good thing. When you read an opinion and you can really remember what that opinion was about because it was an entertaining read, well done. So I like him, I like his philosophy, I like his approach, and I like him making the law accessible to people.
In your question number 15, what's the greatest influence on your ruling? Which creates the greatest influence? Case law, Constitution, or something else? So when you read and you answered the question about the Constitution, so when you said Constitution, did you read that as state or federal Constitution?
It's really both. Under the supremacy clause, the federal constitution gets to come first, which is, quite recently become an issue. But the federal constitution, I think, stands in the first position. However, the state constitution is to be accorded great respect and certainly needs to be a primary concern. Here's what I'll tell you. A lot of times in cases, there's really only going to be one constitution that is at play. If there are two, it's typically going to be because of overlapping positions. And I'll give you an example. I'm sorry, go ahead.
Before you get into the long thing, my understanding is when people are taught in law school, that's what they're taught. They're taught, case law and constitution. But if you were the ones that framed the Constitution, what is their view of what trumps what, state or federal?
Federal.
Okay.
I mean, that's going to be the supremacy clause. The founding fathers made it very clear that the supreme law of the land is the federal constitution. And it literally has language in it that says notwithstanding any law or constitution in the several states. So clearly their idea is that the federal constitution is going to trump the state constitution.
In the powers granted or in everything?
That is a pretty fair question. I think the answer is really in everything, in the sense that, here's what I'm trying to say. The state constitution sets up our system of government for Texas, and it mirrors the way that the federal constitution sets up the federal government. So there's similarities there. With regard to those mechanics, obviously the Texas Constitution sets up Texas state government, the federal constitution federal. But when you're talking about rights, liberties, Bill of Rights, those kinds of things, the federal constitution trumps.
Okay, but as you alluded to, and as Brian was getting around to, there are those areas where some people may believe that the U.S. Constitution is silent. And clearly states' rights was a very fundamental concept in 1787. And I want to tie that into a couple of other thoughts. Not only the supremacy clause, but also the concept of nullification, which can be applied many facets, many levels. Recently, very recently, currently, it is an issue with respect to the president's plans to bring in 10,000 immigrants, and the state's wishes that he doesn't. So how does that play out in your understanding of nullification, of the supremacy clause, and yet there's another one that I heard of recently, doctrine of lesser magistrate, if that applies?
Well, and it's funny, because I was actually going to start with the doctrine of the lesser magistrate. Interestingly, Scalia, in the opinion in, I always forget the name, it's the gay marriage case, he actually speaks about those same concepts. And he literally, this is a Supreme Court justice who is writing an opinion that the majority of 5 has gone so far afield of what constitutional rights actually exist, that substantive due process should not be a replacement, this idea of it should not be a replacement for legislative action of the votes of the people, that really we might not want to follow that. He actually describes it as being akin, the opinion as being akin to a fortune cookie. His sarcasm that I like. And he does. And that kind of fits with the doctrine of the lesser magistrate, that at some point, even though there is a body that is below the more supreme body, there's a time to say, I can't follow that order. And it's really an analysis of something like what Scalia did. Has the supreme ruler gone too far in something that it's done? Has it created a law that actually has no legitimacy because it was created without any authority?
So apply that to Governor Abbott's letter.
I think Governor Abbott's letter is right on the money. I think that the hard, cold reality is that it is up to the state of Texas. Texas is sovereign, and you're right, the Constitution has set up in several provisions that states have rights and they have sovereign rights. Governor Abbott has a sovereign right. Texas happens to share a foreign border. You know, so we've had this position with regard to Mexico and protecting the border before. This really isn't new to Texas. There are very few states that actually have a foreign border, but Texas does. Syrian refugees, he has the right to take a position about that. And if it's counter to what the president wants, but there is no authority for the president to act, Governor Abbott is the one whose decision is the right one.
What if he brings them here anyway?
Who, if President Obama does?
Yeah, and drops them right here.
When he
County.
brings them here.
What's that?
When he brings
Yeah.
them.
When he brings them and drops them right here in the county.
Well, you remember the training exercise in Brenham, and that was back when Governor Perry was the governor, and Texas took a stand. I think that it would be legitimate for Texas to take a stand again. I think Texas should take a stand again, and Texas does have, it's obviously an army, but we do have armed forces. If that's what has to happen, and that would be bad, I would really prefer that not happen, but if that's what has to happen and we have to have armed resistance, or at least loud resistance, that's what has to happen. But the idea, I mean, that idea is dangerous. I mean, these are people who put gruesome videos of violent acts that they commit to send a message. What is that?
It was dangerous in 1776 as well.
It was, and you know what we did? We said that's enough of that. And again, I'll tell you, that's really what Scalia advises with regard to our latest Supreme Court opinion on gay marriage, but he actually says this may be the time. He actually says in his opinion, and you should look, it's really interesting, because he says this is worse than what prompted us to come up with the Declaration of Independence.
Obergefell. I just found it.
Oh, thank you. It's got like an F and a G side by side, and I
Yeah, it's hard.
couldn't hope
I always
pronounce
think
it.
Obergefell, but it's Obergefell.
Obergefell.
All right,
I'll forget that immediately.
In your questionnaire, one of the questions was about an interpreter. And
Oh.
you said, no, the court doesn't have to provide one. I find that just interesting because most of the other questionnaires we've received all say, well, yes. In fact, some of them cited court cases saying why they have to provide an interpreter. So can you explain why you seem to disagree with that?
Yeah. Well, I think your question had to do with illegal aliens. Is that correct? Am I
Yes.
remembering correctly? I don't have it in front of me.
No, it has to do with interpreting.
Well, right, but I thought
Well,
the question was framed in terms of,
Interpreter for non-English speaking illegals. Yes.
yeah.
Okay.
It's the illegals part that's a problem for me. I mean, that's really where I draw the line. And let me be clear, interpreters are gonna be required in criminal cases because of the confrontation clause. Because if someone doesn't speak English, whether they should or not, they don't. When they don't speak English, you've gotta have somebody who can interpret for them so that they can enjoy the confrontation with witnesses against them. Those are criminal cases. It's not a criminal case, none of that applies. If someone needs an interpreter, they need to bring their own, and that's very clear in the law too. That's not a county expense. But when you're talking about an illegal, even in a criminal case, we've got a whole different animal. Because deportation proceedings would be an appropriate response, where you would never even get to the point of having to worry yourself about whether we need an interpreter. And that was one of the responses, I can't remember the number of the question, but you inquired about what to do about illegal aliens that come into the courtroom, and the answer is call INFs to start the deportation process.
Number 18.
So, number 18. So that's why my answer is what it is that there is truly a limited set of circumstances that would require an interpreter at all. And those set of circumstances wouldn't apply in an illegal alien situation.
We have a problem with corruption in the government in Montgomery County. We have a problem with hiring procedures, of hiring family members. We have a problem with somebody gets fired in one precinct and gets hired the next day in another precinct so they can continue on with it, so they can retire. Have you seen any of that out in the community?
Yes. There's a good old boy network that exists in Montgomery County. things have changed some from when I first moved here in terms of how strong it is, but it hasn't gone away. It still exists. And the scenarios that you were describing, yes, I've seen those things happen. It's kind of a matter of, I'll just move from my right hand to my left hand and no one will know the difference, and I can just keep on doing what I'm doing, and it's troublesome. The courthouse is not immune from that, and that is unfortunate, and that really needs to be addressed, confronted, and stopped. You know, I hesitate to be too specific about things because you're putting me on the internet. But yes, I am aware of instances that are very troublesome and do need to be addressed and stopped.
In our questionnaire, we asked how can you change the 410, and you said earlier in the questionnaire, you said 600-700 people in jail waiting for their cases to go to trial. You said that has to stop, I'll stop it. While my opinion will only make it worse. See my opponent will only make it worse. See my response to item 4 and item 4. I don't really, give me a quick overview of how you would get that to happen. How do you accelerate and get this 600-700 people
Well,
faster?
you want to know what's really sad is it's actually not that hard. It really has to do with setting deadlines and sticking to them. Period. You have hearings each and every morning. If you've got a trial coming up, you've got jurors coming in, that's fine. We can have hearings beforehand. A lot of cases can actually get taken care of on hearings. You know, a motion to dismiss would be something that would be a hearing, not a trial. You have more hearings, you have them daily, in the mornings, in the afternoon, before you start something else like a trial. That'll actually take care of a lot of cases by itself. For the ones it doesn't, courts set up scheduling orders. And the reality is, those things get continued time and again. There will be some deadline set for someone to do something in a case, whatever it may be. You have to file this by this deadline. You have to do an exhibit list by this deadline, or a witness list, whatever it is. And these deadlines get missed, and everyone says, oh, well, I'm sorry, we're going to need a little continuance. And the courts say, yes, okay, that's fine, no. No, that's enough of that. Our federal courthouse in Houston, we have judges who set up scheduling orders by the agreement of the parties. Everybody sits down and says, here's how long it's going to take us to do each of these things that need to happen before we can get the case to trial. They agree to that. So absent some truly unexpected medical emergency or something like that, those deadlines are firm because the parties themselves agree to them, agree that this is how long it will take. We can accomplish these goals within these time frames. And what that means is that when you get to trial date, the cases are either going to settle, or in the case of criminal cases, plea bargain, or they're going to trial. You start doing that, by the way, and people quit asking for continuances.
So that's really, the judge has control of
The
that.
judge has complete control over that, and handling that very firmly and not just letting people waffle on deadlines, that moves cases.
Can I-
How long would it take to clear that out and then, okay.
Okay, so that's a very good question, and let me tell you, because that number is not stagnant. I mean, if you were trying to get 700 people out of jail, then I might be able to have a better answer for you, but you're not, because you've got 700 people there now, and then tomorrow it might be 697, and then the next day it might be 705, and then the next, you know. So it varies, because you've got new cases that are coming on as people are going away. Truth is, I don't know how long it would take, but I can tell you this, if we start doing 2 trials in a week with no resets on them, and these cases start moving fast, with a priority given to these criminal cases where people are just sitting in the jails, just waiting. I mean, that one's a real constitutional problem, but you start doing that, and there's no reason you can't. If you can actually pull off 2 trials in a week, then you've got 104 trials taken care of in the course of a year, right? If you use hearing dockets to get rid of a lot of cases and you refuse to negotiate about the trial setting, and so people immediately want to plea bargain those cases, then maybe you move another set of 104 out as well. How long will it take? I don't know. It's gonna take a couple of years, but it's gonna be worse the longer we wait to start.
We've
Yeah,
had,
follow on.
following on that, we've had talked about continuances and how defense attorneys like to have continuance, because it gives their client more time in the county jail versus going to the state. It has witnesses forget things, other things take place, so it's good for them. So we have a judge that issues a lot of continuances currently. And to go along with that, my feelings, and you can answer yes or no, but the lawyers are also making more money off of those continuances because the longer they drag it out. So the defense attorneys are making more money, and it's costing us as taxpayers more money. And I don't see where justice is really being served for a speedy trial, and the need for it is definitely there.
And I'll go beyond yes or no. I'll say amen. And you stole my punchline. I was going to tell you, don't forget about the criminal defense attorneys that make more money the longer these cases linger. And if they are appointed counsel, which is exceptionally common for people that are waiting in jail, that's taxpayer dollars too. So you're paying for all of it. It's time for that to stop. I agree with you. It's just not justice.
Okay. In question number 12 regarding the licensing of barbers and lawyers, why or why not? And you said no and no to each. Explain. I'm not as concerned, I guess, because I just go get a haircut, in the barbering aspect. I don't have my hair colored yet. But on the lawyers, I'm curious why you answered no and why there should be no state licensing from that perspective. So in other words, you indicated in here, you let the people decide who they like. If someone is incompetent, then they cannot do that business anymore. How is the public going to know whether or not someone is competent or successful or not from even a prior case that they had no knowledge of before they go hire somebody?
Well, the answer to that is sort of tricky because people have to know who they're hiring. Just like voters need to know who their candidates are, what they stand for.
But they don't.
They don't. They don't, and I don't mean the voters, the people who hire lawyers. Sometimes they'll just pick a name and that's who they'll go with. But I can assure you that they begin to feel very uneasy about things that are going wrong in their case. And, legal malpractice suits stem from that kind of thing. The other side of that coin too is the lawyer. Because if the lawyer knows that they're not that great and they really don't know what they're doing and this is maybe not the right profession for them, they know what kind of liability risks they take. Anytime a lawyer talks to a client with an attorney-client privilege, whether there's a case or not, you have created a fiduciary relationship between the attorney and the client, and that carries a lot of liability risk with it. So we've got the client who really should be doing homework, maybe they're not, but they certainly know when their case is taking too long. We're not really getting anything done. How come you're not returning my phone calls? Those types of things. They'll fire the attorney and move on. That happens. And then from the lawyer's perspective, if they begin to fear that they're not doing too well and maybe this isn't the right profession for them, the risk of liability will be enough to push them away from the profession altogether. Will that happen in every case? No, of course not. But I'm not sure I understand why the State Bar of Texas has the ability to pick and choose based on a test who would be a good lawyer. There's lots of lawyers who have passed that test and maybe they're not the best.
So what would you recommend, since we have 15 seconds left, as opposed to the state doing it?
Well, no one. I mean, honestly, I think it's a marketplace thing. I mean, look at the requirements to be the President of the United States, or the qualifications. You were born here, over the age of 35, and you've lived here for the requisite period. That's all it takes to be the leader of the free world.
Most
But,
people.
right, well, yeah, some people get a pass on one of those elements, I'll leave that with
Some
someone.
you don't have to be
That's right.
US citizen.
But, I mean, truly, that's, you know, the idea is that those people who would run for president, who meet those qualifications or meet two of the three, that the voters would pay attention to them. The voters would have a reaction to them. I know why you're laughing, and I don't blame you. But the whole idea is that we leave it to the voters. I think the same thing is true when you're dealing with professions. I mean, if I get a really horrible haircut and my friends say, "What happened to your head?" and I say, "Well, I went to the ABC barbershop," they will not be going there. And soon the ABC barbershop will be no more. So that's my idea.
In your opinion, how long is it gonna take to undo some of the precedents that have been set by things that have happened in the last 7, 8 years?
So tell me what sense you're talking about, because I have a heavy side that
Well,
many discuss. So-
Okay, I think of all the executive, some of them are not even executive actions, they just say they're something he's written down on a napkin and
They've become law.
yeah, they become law, just stuff.
Right.
You know, closing the borders for one.
I have no idea. I think so much of that is really gonna depend on what happens in the next election cycle. And if things go the way that they should, you know, Ted Cruz could take care of this in a heartbeat, right? I mean, he's energetic and he understands where the parameters are and he works for people. So he would do it in a heartbeat. Donald Trump, I'm not sure he would move quite so fast, but he could appoint people who would move really fast. Hillary Clinton? Oh, it could be another presidential term before we see any correction about those things. I mean, honestly, I don't know, but I think it really
The
has to
borders
do.
would disappear.
They're starting to,
I mean, they would,
Or have they already?
just like people have disappeared,
yeah.
there'll be more disappearing.
I can't say I disagree. I mean, I think that's where we're headed, and honestly, that makes me come back to your question, Mr. Ward, is that, you know, armed conflict in Texas, we haven't had that in, a century and a half? And, no, more than that, gosh, I'm kind of losing what year we're in.
Century and a half.
You know, it's undesirable. We would not want that. But we're kind of reaching the breaking point, right? I mean, it's kind of reaching the point where maybe we need to start pushing back some. I'm not advocating armed conflict, but what I am saying is that it's gonna take a long time to go through the motions to get rid of those executive orders. And if a Democrat was elected president, which means it'll only take longer, then maybe Texas ought to reevaluate its options.
So, no, the incumbent is not running this court.
I'm sorry, the incumbent?
The incumbent is not running again,
That's
correct?
right.
Okay, so all the problems that's in the current court, you're not running against that, it's just two new people going for this spot.
Yes.
So, I don't know if I'm reading this right, I sense in this question number 4 that there's a little bit of contention between the two candidates, you, the other candidate? Maybe I'm,
What is question number 4? I'm sorry.
question number 4 is please describe what you believe
Or the
are the
biggest
most
issue?
significant issues in this race and why? And you said my opponent, whose experience is strictly in family law, would make it a family court and would submit a type to the courts. And maybe I'm misreading this, but I'm sensing a little. Do you think there's contention between the two candidates?
Yes.
Okay, and can you elaborate a little bit? You know,
When my opponent gave a speech to the Conroe Police Department, it's on the internet and you are free to take a look at it, probably should. She describes the fact that there were 1,100 changes to the family code in the last legislative session, so it's very important for judges to be very up on the cutting edge of the law as it exists in these different areas. So her idea is that she is a family lawyer and she knows family law well, and so this court should be a family court to address those issues. Okay, that's a debate about whether we should specialize the court or leave it a multi-jurisdictional court, and that's where I take issue. The idea of specialization it sounds good, because you sound like you're gonna get judges who are very knowledgeable about some area of the law, and all the cases they hear are with that area of the law, so you're gonna get efficient rulings, good rulings, that kind of thing. How it works in practice, though, is something that we really can't ignore. Because the one thing that it guarantees, no question, is an unequal distribution of cases. And that's when we start running into these backlog problems that have just been prevalent. Because I will tell you that some of these backlog problems, some of these numbers that I'm able to cite you to about people in the jail and all, these are things that happened after we started pushing some of our district courts towards specialization. The 410th and the 435th are not specialized courts, they're multi-jurisdictional courts. My feeling is that works better, because then judges can share cases with each other. If some judge has plenty of time for some reason and another judge is buried with work, they can share them. But if the two courts at issue are a civil court and a family court, there's no sharing that's happening. That's not good for the public, that's not good for the community. So that's where we disagree. Her idea is that a specialized court is a good thing to have. My idea is it doesn't work well in practice, it leads to backlog. We need to have a court that's available for the public. That's the clash.
So it's not really a, okay.
Can I expand on that just a little bit?
That's right.
Who determines whether it will be a,
Specialized or not?
I'm glad you asked. There is actually a legal procedure for that to happen, and it's not just a matter of a judge deciding, I think I would not like to hear criminal cases anymore, I'm only going to hear these. That is not an option. What happens is the Board of Judges meets, that's all the judges of all of our courts, the courts in the county. The Board of Judges meets, they do an analysis, they make some decisions, they make some recommendations, they vote, they exchange thoughts and ideas, and ultimately they come up with a resolution about what they want to do about specializing courts, if they do. Once that happens, that petition goes to Olin Underwood, who is the administrative judge over the 2nd Judicial Region, which Montgomery County is located in that administrative region. He has to put his seal of approval on it, and the reason he does is because he's in charge of assigning visiting judges for all these courts in all these different counties, and he has to have some control over how the cases are distributed so that he'll know how to do his job. So if he puts his seal of approval on it, then it goes to the Supreme Court, and it has to be a 9-0 decision. The Supreme Court has to approve those choices. If all that happens, then there's a change to our local rules, the Montgomery County local rules or whatever county's local rules, and now it's become part of the procedure about how we're going to do things. It's really not up to one judge to make that decision, but what judges can do, absent that procedure, which is designed to be difficult so that we get equal case distribution and cases get resolved quickly, justice is served. If we want to skip that procedure, what judges can do is they can transfer cases between them. And that happens a lot. There's an example that I gave you earlier. One judge just has nothing to do that day for some reason, and another judge is buried with work. They can transfer cases between them.
do they?
They can, and sometimes they do, but right now, our district courts are not doing that. Our county courts at law did it that way for a really long time, and ultimately that experiment worked for them. They're part of Montgomery County's courts, but they have different jurisdictional schemes. So what works for them doesn't necessarily work for the district courts. It did work for them. They did this procedure. They got the Supreme Court to approve specializing those courts, and that's what they've done. But before they got that approval, they would transfer cases between themselves to see how that worked for them. District court judges aren't doing that. Our district clerk is actually just filing cases based upon the designations that these courts have sort of taken on by practice. The one exception is the 418th, because when the legislature set that court up, it's a general jurisdiction court, but the legislature did say to give preference to family cases. So that one sort of has, the family court approach to it. It's not limited to just family court or family cases, but that one is its own little animal. And of course, the 435th, up until this last legislative session, had its own function that it no longer has, and now it's general. Everybody else, it's general jurisdiction. There's been no official rule change, and they're not transferring between themselves. Is the way the district clerk is filing the cases.
Okay, you were asked earlier about the types of cases that you have experience with, and you gave 85% and so forth. I want to take that same general thought and slice it a different way, and let me ask you this way. How many cases have you tried as either whether it's prosecutor, plaintiff, whatever, on that side, versus how many of you been on the defense side, defending client against whom a suit's been brought? And in conjunction with that, what's your win percentage? How many times have you come out on top? The person you're representing walked away with a smile on their face versus the frown. And talk about reversals.
Okay. I'm mostly smiling because I actually prepared a table of all the cases that I tried, which side I was on, and what the outcome was, and now I'm sitting here thinking, why did I not bring that to you tonight? Oh, no. So,
I'll give you
anyway.
my email address.
Okay, I will send it to you. I had it and I thought, oh no, they won't want that. Now you ask me this and I'm thinking, with that being said, I will send it to you. So don't hold me to the exact numbers, but this is my recollection of how it plays out. My win record is better than my loss record. That's number one. Number two is I have represented plaintiffs. I've represented people that are advocating for a position against someone else, but mostly I'm on the defense side. That's pretty common. Business owners that get sued. We represent builders. I say we. My husband and I have a law practice together, and we work together. That wasn't the royal we, but we work on both sides. So our preference is really defense. I like the defense side better. So there's that. You asked about reversals. I have one reversal that is a very unhappy one for me because it's a recent one. And that one came out of a judgment in Harris County. So that one makes me very sad. And that's the one that sticks foremost in my mind because it's a recent one and that one hurt. But for the most part, the decisions that I get out of cases that I've tried are affirmed. I do actually do a lot of appellate work that has to do with cases I didn't try. It's someone else was the trial attorney and I handled the appeals. I also have a chart of all the appeals that I've handled and a description of which side I was on and what the outcome was, so I will email that to you as well.
Great.
All right, so a trend that has become noticeable, whether or not it's increasing or not, we'll just have to wait and see. But it seems like there's a trend of doctors that find these cases of children with rare diseases, and they decide on a course of action that the parents disagree with. Very often the parents have their own set of doctors that say, no, we want to do this course of action. And yet CPS gets involved and they side with this other side and CPS takes control. So what's your position on that? When is it appropriate for that to occur? When is it not appropriate?
With the scenario you described, the answer would be never. And you asked a question that was similar to what you're describing in the written questionnaire. And that's, with my answer on that, I said, let's define the issue. I mean, if we're talking about court intervention because some parent is abusing a child, then by all means, we should take care of that criminal activity and protect the child. But the scenario you described was the one that I said, but if. Parents are the parents. I mean, raising children, it's hard. It's really hard, and nobody ever trains you how to do it, but it's the parents who make the decision about moral upbringing, about religious upbringing, and about medical care. And it may be that CPS doesn't agree with what's happening, but unless we're really actually dealing with a criminal case where a parent is truly abusing a child, beating them, whatever, the CPS needs to stay back.
So even if the child's in the hospital, the doctors are saying, well, if you remove her from the hospital, she's going to die.
I know. But, doctors, you can find a doctor who will say anything, right? I mean, how many kids were diagnosed with ADHD, and how many times did we hear about, yeah, right, exactly. There are like medical trends, and a lot of doctors jump on the bandwagon. If we actually take it too seriously to the point where we're saying, well, this doctor said it, and therefore it is true. As a result, CPS, you need to move in and take care of this child, because what the parents want is not what that doctor wants. And so we're going to just take the decision completely out of the parents' hands. That's not okay. I mean, that's seriously overreaching. CPS needs to stay back. they have a function, we understand what their function is, but once they start taking over as the parent in a case where there isn't criminal activity that warrants it, and that's why I keep giving that caveat. I mean, we understand the difference. You know, a case where a parent has a disagreement with some doctor, parent chooses.
Okay, we've got about 5 minutes left. I think 2 more
Gosh.
questions.
As an elected official, you have no time schedule. You have no set time that you have to actually be at work or the number of hours that you have to work. People expect at least a 40-hour work week from anybody that they're paying to work, and an elected official is paid to work. That's not the case in most of our courts.
Right.
And that goes not only for the judges, but their staffs as well. How do you feel about that? Are you gonna make any changes?
Yes. How do I feel about that? You know, I'm a taxpayer. I'm running for office, and I'm hoping to become an elected official. But whether I am or not, I'm a taxpayer, and it's a problem that we are paying people to not go to work. That's not okay. I'm not okay with that, and that's not something that I would condone. I will tell you that what you said about the hours can be flexible with the court. You know, we've had some judges that have actually dealt with those issues by having a deal where members of their staff could miss every other Friday, but they have to come in at 6 a.m. or something like that. Those judges are gone. But they insisted on a 40-hour work week from their staff. And they could be flexible about what days they were working or that kind of thing, but the number of hours and the work and the tasks performed had to happen. I don't even want to really do that kind of flexibility. I really expect people to be at work because the court has to be accessible to the people. And the elected official, I'll be watching myself. If my numbers don't go down, the numbers that I'm citing you, if those aren't going down, I've done something wrong. I'm not working hard enough. That means put in more hours. I'm a workaholic. I really am. And that's not going to change. It's not going to change because I'm actually telling you things that I want to do, and if I don't achieve them, that would bother me more than it would bother you. So I'll make it happen.
Okay, if I'm what determines that I'm indigent as a defendant?
It's the poverty line that's set by the federal government, but if what you're asking is what does the county look at in making the decision, is that what you're asking me about? Okay. They're going to ask a series of questions at the jail. That's something that the magistrate does, Paul D'Amico, and he'll ask those, well, sometimes it's not, but anyway, they ask the questions about, do you have a job, do you have a home, where do you live, you know, those kinds of questions. And when the answers are nope, 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 and under I-45, then the answer becomes they're indigent, but they actually dig a little bit deeper. Sometimes they'll look for records, and especially if somebody gets a bail bondsman, then they want to know where the money came from for that. It's not enough. I mean, the reality is, in probate cases, we have to dig around for assets. Probate cases involve someone who's died. If you have a person who's going to come in and take control of a deceased person's estate and they don't know where all their stuff is, you have to find it. And it's kind of like looking at a needle in a haystack. You basically have to get one clue that will take you to two more that will take you down the line. Because honestly, you know, nobody really knows where someone's bank account is unless you happen to have gotten a check from them. That kind of investigation would be appropriate before we start spending a lot of taxpayer dollars on attorneys.
So does it differ whether it's civil or?
The analysis, it does, but it shouldn't. And now, in civil cases, you're not going to have appointed attorneys, except in cases where you have unknown people, unknown heirs, or somebody that can't be found for service of process or something like that. It's not that common to have attorneys appointed to actually represent someone, except in the cases of missing persons. In criminal cases, it's all too common. So the screening process really should be more involved. That's what I think.
Okay, that wraps up the questions. If you'd like, take up to 5 minutes on the close, and or we can ask more questions if you like.
I was actually going to ask you if you'd ask more questions. Is that okay?
Okay, sure.
Or would you rather just go home? Maybe I should say
No,
that.
we're not gonna let you off that easy. Okay, so in question number one, you said your judicial philosophy is strict, construction. And as a result, judges should enforce the law as written, or letter of the law. How does that differ with spirit of the law, and where do you come down on that?
The spirit of the law? I don't know what the spirit of the law is. I mean, I went to law school, I've been a lawyer 22 years. I'm not real sure what the spirit of the law is. It's that kind of terminology that I think kind of opens the door to interpreting words in a way that they weren't meant to be. And so I don't really buy into the spirit of the law. I buy into what words were used. And I will tell you that there's actually lots of case precedent and a statute called the Code Construction Act that relate to there is no real spirit of the law. We interpret documents based on the words that are used because those are the words that the drafters have chosen. That's the words that they've picked to convey their meaning. Those words have to be interpreted as written. So the spirit of the law is, to me, that just kind of opens the door to interpretations that could vary widely depending on the proclivities of the interpreter. The words that are written, they have a meaning.
Pass.
So let me kind of jump in on that. So, is it possible to write law that can, say a Texas that can, I don't know how many Texas there are, but can work for 20 million people? Is it possible to write law that you don't have to use common sense, that you can use the letter?
Well, common sense, that makes sense when you're reading something to use that. But the words that are written have to be interpreted as written. And yes, I do think it's actually possible to do that. I mean, that's when the legislature meets, they do have unique statutes that would apply only to counties of over 500 that are next to counties that, we all know Montgomery County. So they do have those very special laws. But for the most part, what comes out of the legislature every 2 years are laws that are supposed to be applicable to everyone across the state.
So let me ask you this. Are you familiar with the recent controversies over election law and all that?
No.
Okay. Well, there's a case over...
Is this voter ID issues?
not voter ID issues, but residency issues.
Oh, yes.
Okay, so you're,
I
okay,
have
so
familiar.
is it possible, so that has to do with presidents who live in Washington and want to vote in Texas, and students who live in, Magnolia but want to go to school at A&M. So if it's possible to write a law that fits 20 million people, we've only been in existence for 40 years. Why haven't we been able to do one yet?
Well,
Obviously the current law is not work. Why can't we do that?
I think part of the problem is that we're having some conflict between the federal government and the state government again. The reality is the Constitution says that the states figure out their elections. There are certain parameters about when these elections have to happen and so forth, but the idea of the elections is something that the states figure out on their own. We have state law related to how our elections happen. We have an elections code. So that is really designed to apply to Texas. Now, when we start having some federal laws related to residency requirements, that doesn't really make a whole lot of sense because that's sort of outside of where the federal government is supposed to intervene.
Well, the question I was asking was back to the letter of the law, and, you kind of took it into the federal realm, which I didn't totally understand.
Sorry.
No, that's fine. I mean, we're here to understand how you think and understand that. So, okay, I'm not sure what I'm trying to say.
Well, let me ask, okay, are you asking me about residency requirements that relate to the scenario of college students? My son
No, I'm
lives
asking
here.
about the rule of law
I mean,
versus...
it seems like there's
versus-
a different, in the case that he's mentioning, which is the Red 7, there seems to be a different application of the same law or
The
interpretation.
law is vague.
Okay.
The law is vague,
Okay.
and so there is letter of the law, which is ambiguous, and then there's the spirit of the law. What is the
Okay.
real intent here? Because what you've got is, a couple guys that are facing prison,
Right.
as opposed, in the Red 7 case, as opposed to the MUD, which has been in the papers,
And no one
but no one
cares.
is pursuing, no
Right.
one cares.
Okay.
And so we're looking at, is this a vendetta thing, against these
but-
guys? Or
Well, I
is
didn't want to
this-
get off on the Rudd's case. I was
Well-
trying to go off the letter of the law issue, and can you write law to fit?
But it's the same law
These-
that's governing both.
Yeah.
This one is not okay, but this one's okay, and they're doing the exact same things. Other than one's getting paid
Either
to
of
do it.
them, okay.
Let's let her-
Well, so let
Well,
us know what your
okay.
thoughts are in regards to that.
So let's do this kind of, I'm sorry. kind of
As it pertains to election law. Yeah.
a step-by-step sort of approach. We start with the words that are written. I mean, this is actually stuff that the case law and that there are statutes that relate to how we construe things. This is true for contracts as well as statutes. So this is kind of the rules that we do. We start with, what are the words? If they have a plain and ordinary meaning, those are the definitions that we apply to them. If they are defined within the document, and you know how people do that, and so if it's defined within the document, you use the definition within it, which then opens the door about whether the words that define the word are plain meaning. But you get through that. If there is an ambiguity after that, then you start looking at intent, and I think that's what you're referring to as spirit of the law. But the intent is not just, well, this is what we imagine the drafters had in mind. Instead, it's literally looking at things like legislative history. What was being debated in the legislature at the time that this was passed? So it's not just a vague imagining of what those words might have meant or what they might have had in mind or how we would like to apply them because it's serving our purposes for the moment. Instead, it's really a scholarly approach to looking at evidence. I can tell you that Justice Scalia isn't fond of legislative intent because his whole attitude is, if it's not in the statute, then we don't care what their intention was because it didn't make its way there. That's kind of the debatable point. I tend to side with him. I know that there are statutes that have words that are ambiguous. I mean, it would be foolish for me to pretend that everything is well written. We've seen some that are very poorly written. But it's important to look at what the words are. It's important to look at the time that it was created. It's important to keep in mind what was happening when the law was passed, when we are delving into interpreting it. As soon as we're willing to walk outside of those lines, we've kind of opened the door to people saying, well, here's what that really means. And everyone else says, what? How could that possibly mean that? And you say, well, because I'm the judge, and that's what that means.
Isn't that what case law,
So-
isn't that what case law does?
Case law does do that, but if you have judges that stay on course, then it's actually okay.
That was a big,
But-
very big if.
Very
big if.
That's an enormous if. And I can tell you, Corpus Christi, Texarkana, stay on course now. No, those are the ones that are very typically making new law for us. So.
Anybody else?
How about I throw you a softball question?
Great, thank you.
Why did you choose to run for the 410th and not your husband?
You know what? That may not be a softball question.
I doesn't say.
And y'all are gonna put me on the internet. But he actually, he didn't want to. He really didn't. We joke about in our practice, we've been in law together for a really long time. And we always joke about how I'm the law person and he's the fact person, because he's the one who meets with clients and goes to mediations and talks to witnesses, and he's the one who kind of deals with all the fact gathering and reviewing documents and stuff. While I am doing legal research and legal analysis. I argue the cases to the jury, he questions the witnesses. I argue motions to the court, he gathers the evidence that I need to bring with me to show to the court. That's how we work together, and it's a good fit, because that's what his strength is, and this is what my strength is, and we work together cooperatively. So for him, he doesn't want to be on the bench. He likes interaction with clients, and he likes working for clients, and it's not that I don't, but what I really love is the law, which kind of brings me full circle, so.
Along that same line, if I may, how is that gonna, how are you gonna handle not having a conflict of interest?
I won't, I will have a conflict of interest. I mean, I'm not even gonna hem and haw about that for you. If my husband has a case that's in the 410, I will not be hearing it, that case will be transferred out. There's no question about that. In fact, we have joked that if I were to be elected for the 410th and somebody decides that they want to not be in the 410th, then it would be very easy to hire my husband as local counsel and ensure that the case is transferred out. We're saying that jokingly, but I would not be able to handle any cases involving him.
So what happens, is it automatic, the cases maybe that are pending, that you're getting ready to go to trial on or something, that might go to the 410? Is that an automatic, they'd be,
It's not,
it's up
but,
to you?
right, that's right, that's right. But I can tell you right now, I will not be hearing any cases that involve my husband.
So kind of like soda
Okay.
mine.
All right, great. Well, thank you very much. We're gonna
Thank you.
wrap it up.